Can you trademark a name for your business? The short answer is yes, but there are specific requirements and processes you need to follow. Trademarks protect names that identify products or companies from competitors. The U.S. Patent and Trademark Office can register an individual's name as part of a trademark, but only grants protection to names that are extensively used in commerce or are distinctive. To qualify for trademark protection, a name must be used in commerce and have distinctive qualities. Personal names must acquire what's called secondary meaning. This happens when your name becomes widely recognized in connection with specific goods or services. For example, Morgan Freeman successfully won the right to trademark his name after it was illegally used in a domain name to divert traffic to a commercial search engine. The trademark application process involves several key steps. First, determine if your name is eligible by ensuring it's distinctive and used in commerce. Next, conduct a thorough search using the USPTO's TSS database to make sure no confusingly similar marks already exist. Then identify the appropriate goods and services categories for your name and choose your filing basis, either use in commerce or intent to use. Submit your application online through the USPTO's TIS system, with fees ranging from $250 to $350 per class. Be prepared to respond to any office actions within 6 months if the USPTO raises concerns. Your name will then be published in the official Gazette for potential opposition. If unopposed or successfully defended, your mark proceeds to registration. Not all names are equally easy to trademark. The best names for trademarking are either fanciful or arbitrary. Fanciful names are completely made-up words with no connection to the product or service, like Yahoo. Arbitrary names are real words that have no logical connection to what they're selling, such as Shell for a petroleum company. Generic or merely descriptive names like Best Pizza are much harder to protect. Once you've trademarked your name, you must actively protect and manage it to maintain your rights. The USPTO doesn't monitor or enforce your trademark. That responsibility falls entirely on you. Regularly check for unauthorized use, especially by competitors. If someone does use your trademark, you need to demonstrate that there's confusion in the marketplace and that this confusion is causing you financial harm. For example, if your trademark name is Blue for financial services, another business using Blue for a restaurant likely wouldn't cause confusion. However, Blue Finances would probably infringe on your trademark. Even without federal registration, you may have common law trademark rights. Once you start using a name in business, you gain rights within your local geographic area. However, these rights don't extend nationwide and offer less legal leverage in disputes. Federal registration provides much broader protection and allows enforcement in federal court. Domain name protection is another important consideration. The Anti-Cybersquatting Consumer Protection Act helps guard trademark owners from domain name squatting. Under this law, a trademark owner can sue for damages and recover a website name from someone who registered it only to sell it to a company with a similar or well-known trademark. The Internet Corporation for Assigned Names and Numbers also provides an online arbitration system to resolve domain name disputes. Trademark applications can be rejected for several common reasons. These include lack of distinctiveness if the name is generic or merely descriptive, likelihood of confusion with existing marks in the same industry, failure to use the name in actual commerce, or submitting improper specimens that don't clearly show use in the marketplace. After registration, use the registered trademark symbol. Maintain your registration by filing required documents periodically, monitor for infringement, and be prepared to enforce your rights in court if necessary. Failure to maintain and protect your trademark can lead to its cancellation. While you can file a trademark application without legal help, consulting with an intellectual property attorney can be valuable, especially for complex situations or if disputes arise. The trademark process typically takes 6 to 12 months, but provides protection that can last indefinitely as long as you complete regular renewals and continue using the mark in commerce. Remember, trademark protection isn't automatic. It requires active maintenance and enforcement, but when done correctly, it provides valuable protection for your business name and brand identity in the marketplace.